On the record in the matter, the people of the city of Lansing versus Timothy Clark, file number 23-01148, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Timothy Clark.
Okay, today's the date and the time that is set for pre-trial. How are we proceeding?
Your Honor, Mr. Clark has entertained the offer from the city attorney, but at this point is declining and would like to set the matter for trial.
What was the offer?
The offer was to plead guilty to one of the charges and the other one would be dropped.
Okay, there's count one of hinder, obstruct, and oppose. The other is disturbing the peace. The offer was to plead to one and dismiss the other.
That's correct.
Okay, Mr. Clark, you want to decline the offer? I can't hear you, sir.
Yes, I do, Your Honor.
Okay, so we'll set this for trial.
September 12th at 8:15.
September 12th at 8:15. What is he being held in custody for? Not on this, correct?
No.
Okay. Oh, okay, he has another matter. I think, did I just see you the other day? I think I did. Okay, do you have any questions today, sir?
No, I don't.
Okay, any additional matters for the record?
Nothing for the city, Your Honor.
Nothing for the defense, Your Honor.
Okay, you're all set for today.
Good to go?
You're good to go. Okay, let's see. Mhm.
While we were talking to,
Thank you.
It's cold.
Okay. Tiana Alexander present. Okay. On the record in the matter, the people of the state of Michigan, I'm sorry, city of Lansing versus Tiana Alexander, file number 22-03276. Appearance, please.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of Tiana Alexander.
Ms. Alexander, can you hear me?
Yes, ma'am.
Today was the date that was set for a hearing for a probation violation. How are we proceeding, counsel?
Your Honor, Ms. Alexander wishes to plead guilty with an explanation.
Okay, the violation, Ms. Alexander, is that you failed to submit to random testing back on May 27th, May 28th, June 8th, June 12th, June 18th, June 28th, and July 5th. You want to waive your right to hearing and plead guilty to those violations?
Yes, Your Honor.
Okay, you understand that a violation of your probation could cause your probation status to be revoked, or it could be extended, or you could also have increased sanctions and oversight imposed, or you could be sentenced to a term of jail time for the violation. You understand that?
Yes, Your Honor.
Okay, you still want to waive your hearing?
Yes.
I don't know. Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, so
I
I think
do.
the problem is wherever you are, you
Yes,
don't have
Your
a
Honor.
good wherever you are, you don't have a good signal. It's telling me that you have low bandwidth.
Um, maybe is that better?
Okay, okay, sounds good. Okay, so ma'am, you have again waived your rights to proceed with the contested hearing. You are represented by counsel today, and the violation again were that you failed to test or submit to random testing as ordered by the court as part of your probation status on May 27th, May 28th, June 8th, June 12th, June 18th, June 28th, and July 5th. As to each of those dates, how do you plead?
Guilty, Your Honor.
Factual basis.
Thank you, Your Honor. Ms. Alexander, were you sentenced to probation on case number 22-03276-OD?
Yes,
And as part of that probation, were you ordered to submit to random drug testing?
yes,
And were you notified by the probation department that you were to show up on May 27th, May 28th, June 8th, June 12th, June 18th, June 28th, and July 5th to participate in these random testings?
yes,
And did you show up to get tested?
no, I was not able to.
Thank you. No further questions, Your Honor.
Okay. The court is satisfied with the factual basis. I will accept your plea and find your plea to be made freely, voluntarily, and intelligently. The recommendation from probation is to continue your probation right now and to hold jail time of 1 weekend in jail in abeyance, pending any further violations. Let's see. Well, she said it's to non-reporting probation.
Yes.
Okay. They want your status amended to reporting probation at this time. And it says that your first test was positive for THC, however, you never continued to test, and that you provided proof that you were medically unable to work, but does not have means to pay. You also provided proof of being denied disability. You can address the court, Ms. Julie.
Thank you, Your Honor. As the court is aware, and was aware at the time of fashioning Ms. Alexander's probation, she has suffered from a traumatic brain injury as a result of the accident that led to these charges. She has also suffered from PTSD and chronic pain, specifically to the left side of her body. She has provided the probation department with those letters from her physicians that establish that those are bona fide, verified medical conditions. She has also provided letters stating that she's participating in mental health treatment, physical therapy and occupational therapy, as well as speech therapy. The real issue for Ms. Alexander in regards to probation and the requirements of probation are funds and transportation. She has literally been written off of work, so she's not working. She lives in a home provided by her family, and it's her family that is paying for anything she does on probation and providing the transportation. When I read that list of dates, it occurred to me that, that was 4 times in June, 3 or 4 times in May. It seems as though probation wants quite a bit of testing. And maybe if we could adjust it.
I don't think it's that they weren't quite a bit of testing. She probably didn't report, so they changed the date because she didn't go the first time.
Oh, that could be too.
Yeah.
That could be too.
I don't think that you're requiring her to test that often.
And that's all we can really ask, Your Honor. The non-reporting was fashioned for her to be on account of her medical conditions. And I don't know, she's throwing herself on the mercy of the court and asking that somehow her probation requirements be, once a month testing or something that she can go to her family and get the required support.
The records I have would indicate she didn't test at all in May or June.
I think her first test, she went and took a test. It did come back positive for THC, but again, she was good about communicating that to probation. I told them that it probably would.
Okay. And she doesn't have a valid medical marijuana license?
Apparently not.
No, ma'am, not.
Okay. When's the last time you tested?
Honestly, I can't remember.
Okay, so I'm not sure what was being sought here. You want to be placed on a term of probation and then no oversight, she can't really test. How is that beneficial or meaningful? And then we find that she has a substance in her system, at least on the one time that she tested, that she doesn't have a valid prescription for, which is in violation of her probation.
Yes, and we agree, Your Honor, that she should test. If those dates are just all reset dates and not like, she has to go every 6 days, yeah, that's entirely reasonable and she should test. The only reason we ask for the non-reporting is because of her medical conditions and such that she's already at the mercy of people in regards to getting to medical appointments and everything else.
Right, but the non-reporting, even reporting, she would be reporting via Zoom. It wasn't that she had to come in for a hearing or to report with her probation officer. And then I did the non-reporting as a way to kind of try to offset the costs so that she can focus on testing. But that hasn't happened either. And I recognize and I can appreciate that she's in a situation where she's not able to work. She created the situation that she's in and placed herself and other people at risk for extreme harm and or death. She could have killed herself by being under the influence of while operating with a blood alcohol level of 0.219. And so we can't address any issues if she doesn't comply with the probation. She knew this was a condition of probation when she agreed to it. She knew that. The alternative was to do jail time. She said she would do this. So I don't have sympathy that you're gonna have to ask your family to get you some money so that you can go do your testing once a month like you're supposed to. She's got braids down to her derriere right now. That hair ain't free. You can ask for money to do that. You can ask for money to comply with what's going on here. And so I'm going to amend the probation to reporting because we're not getting what we need taken care of now. I'm going to order that she tests once a month. I am going to hold 1 weekend in jail in advance. And it'll be suspended upon successful completion of her probation with no further violations of the orders to participate in her testing. If she's going to get a positive THC, she's going to need to show us that she has secured a marijuana card in order to do that. Do you have any questions about the order of the court, Ms. Alexander?
Yeah, am I still gonna have to drop twice a week?
No, I'm ordering that you are dropping once a month, but I'm now ordering that you're on reporting probation. You're also gonna have to report monthly. You'll be reporting via Zoom, okay?
Okay.
Okay, any additional matters for the record today?
Nothing for the city, Your Honor.
Nothing for the defense. Thank you.
Thank you. You're all set, Ms. Alexander. Sean Bearden, present.
No, Your Honor, Mr. Bearden informed me this morning that he would not be here today because he had a dying uncle that wasn't aware, he said wasn't aware of the court date until I told him yesterday. So I tried to get him, left him a message to say that he should at least try to appear by video, but I haven't seen him.
He was pretty much aware because he appeared in the court. This was a situation where he was supposed to have the hearing, and I think we had a trial, and the attorney called him off, and he came and told me, the attorney told me it was canceled. So I gave him the new date at that time.
Yep. And a notice was generated, yes.
Okay, well, we'll issue a virtual. Craig Garner. Okay. On the record in the matter of the people of the city of Lansing versus McCraig, Doris Garner, file numbers 23L279562 and 621, council appearances.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of McCraig Gardner.
Mr. Garner, can you hear us?
Yes,
Okay, we have two files here. One is for a failure to display operator's license and a speeding 1 to 5. Was there an offer on this, Mr. Staples?
Yes, I believe there was, Your Honor.
excuse me, could I speak with my lawyer for a second?
The offer on this ticket was to amend to an allowing and waive the ticket unless he was working on getting his license, in which case the city would have no objection to giving him time to do so.
Okay, and I'm assuming you've not spoken to him?
I have spoken to him.
Okay,
He did inform me that he was working on getting his license. I'm not sure what it is he wants to speak to me about today, but
okay. Mr. Garner, you're seeking to obtain your license, or you need to talk to your attorney about what's going on?
Yes, I am in the process of getting them back. I did retain a lawyer, Michael Mataloni, and he asked me to speak to the court and ask them to adjourn my court date until he could be available, if that was okay.
Yeah, you need to file a substitution of counsel so that he can prove that you hired him.
Okay.
And we've
how would
not
I be-
received that. So
How would I be able to?
he knows how to, he has to do it. You can't do it. He has to file a substitution. He would need to get this attorney to sign off, and you would sign saying that he's hired you. We've not received that yet, but we will reset this, and then he can file that substitution, okay?
Okay.
August 29th at 10.
August 29th at 10.
August 29th?
That's correct.
All right.
Do you have any questions today?
No, I don't. I appreciate it.
No problem. You're all set for today.
All right. Thank you.
You're welcome. Nia Johnson present.
yes, she is, Your Honor.
On the record in the matter of the people of the city of Lansing versus Anaya Lenise Johnson, file number 21-00890. Council appearance.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of Nia Johnson, who is in the courtroom standing to my right.
Okay, today was the date set for a free trial for driving while license is suspended. Was there an offer on this?
Your Honor, this would be a similar offer to the prior, that the city would be willing to amend to allowing suspended, but if she is working to get her license back, we would have no objection to giving her time to do so.
Mr. Staples, how does your client want to proceed?
Ms. Johnson has informed me that she is getting ready to pay the Secretary of State the balance, the remainder of the balance of what she owes this Friday, August 11th. She is working 2 jobs, and her second job, she said, pays her Friday. So that's when she intends to pay the remainder of what she owes. And it is her understanding that at that point, she'd be able to utilize it back.
We'll reset this.
August 29th at 10.
August 29th at 10. Have any questions today, Ms. Johnson? No, ma'am. Okay, any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Nothing for the defense. Thank you.
Okay, we'll get you a copy of your notice to appear, okay?
Thank you.
You're welcome. On the record in the matter of the people of the city of Lansing versus Alexa Jones, file number 23L2797963, counsel appearance.
Matt Staples, for the city of Lansing.
You have an attorney, ma'am?
No.
Okay. Did you request court-appointed counsel? No, I'm asking you, did you request an attorney to be appointed to represent you?
No, I did not.
Okay, so you want to represent yourself?
I don't think so. No, I don't.
You do not want to represent you, want an attorney to
Yes.
represent you? Okay, so you need to do an intake if that's the case, okay?
Okay.
Okay. So we'll,
Yeah, so Your Honor, she was able to provide me, she has a valid license
oh, she
now.
does have a valid
She didn't have
license.
it at the time, so the city would move to dismiss the charge. It was written on the ticket.
Then you don't need to get an attorney, see?
Okay.
So you're all set. Thank you.
Thank you.
You're welcome.
You could try to speak to Ms. Donnelly about maybe getting an attorney for that. Otherwise, you would have to speak to a private attorney.
Thank you.
Okay, so that one. And then, is the ticket even attached to this? Oh, okay, it was. Did she have other ticket or issues with the other 2 tickets? Is that what it was?
Yeah, there were 2 civil infractions as well on the file that were
That was
defaulted.
defaulted, and that's what she wants to address?
Yeah, they were just defaulted on the 31st, so I
Can you
think
have her come back here? All she needs to do is make a motion. Mr. Bigelow, can you have her come back so we can address those civil infractions?
just her and Ms. Donnelly have been speaking about it.
Yeah, she just needs to make the motion. If she leaves here without doing it, she might miss the deadline. Back on the record in the matter with Ms. Jones. Ms. Jones, I did look at your citation. You did have, it looks like 2 other civil infractions that you failed to appear on the 25th, so they probably are in default. I don't have them before me, but I'm assuming you want to make a motion to set aside the default? Yeah, correct. Okay, we'll set aside the default and set those for an explanation hearing. Let's see.
We can do August 29th at 10:30.
August 29th at 10:30 will be the explanation hearing on the other 2, okay?
Okay.
We'll get you a copy of the notice to appear. You can have a seat real quickly.
Thanks.
You're welcome. Whenever you get a chance, we need to pull that other file and set aside the default. Let's see. On the record in the matter of the people of the city of Lansing versus Danny Lang, file number 19-05001, council appearance.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of Danny Lang.
Today's date and the time set for hearing on a probation violation. You were arraigned on this violation back on July 25th. The violation alleges that you tested positive for alcohol at EverHealth back on July 6th for alcohol with an ETG greater than 25,000 nanograms, ETS of 14,175 nanograms. You are represented by counsel today. How are we proceeding?
Mr. Lang is going to plead guilty to the probation violation.
Is that correct, sir?
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Thank you. You can put your hand down. Again, you've been advised of the alleged violation, and you have the right to have a contested hearing today. You have the right to have the probation department and the city attorney's office put forth evidence to establish if you in fact violated the terms of your probation. If you are found to be in violation of your probation can be terminated and you can be sentenced to a term of jail time, or it can be extended, or I can impose increased oversight and sanctions. Do you understand that?
Yes.
Okay, do you want to waive your right to hearing today? Okay, is anybody threatening you or making any promises to you to get you to plead guilty to the violation?
No.
Okay, as to the violation that you tested positive for alcohol and there's two separate violations. As to the violations that you tested positive for alcohol back on July 6th, the ETG, 25,000 nanograms, how do you plead? As to the violation that you tested positive for alcohol on June 24th and June 26th with the ETG of 11,125 and an ETG of 6,286 respectively, how do you plead? Factual basis.
Mr. Lang, in regard to case number 19-05001 OD, you were sentenced to a term of probation for alcohol-related offense, correct? Yes, sir. And as a part of that sentence, you were instructed to participate in random testing for alcohol, correct? Yes, sir. And on June 24th, you reported to the lab at EverHealth and gave a urine sample for that purpose, yes? Yes, sir. And that urine sample showed that you had tested positive for alcohol, correct? Yes, sir. And that also happened on June 25th and July 6th. Yes, sir. So on those dates, it confirmed that you had in fact consumed alcohol, correct? Yes, sir. No further questions.
Any questions from the city?
No questions for the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. The recommendation at this time is to continue your probation, but to add intensive outpatient and a sober link. Jan 12 set meetings. It says the defendant needs to address his continued use of alcohol. All tests have been positive for alcohol that you admitted to drinking monthly at your last use. I think at the time of this recommendation was on July 9th. Mr. Lee, you can address the court.
Thank you, Your Honor. Mr. Lang does admit that he needs alcohol counseling and that the testing is good for him because it helps him to have motivation to not drink. That is another motivation. He has, since those tests tested negatively, he is attending AA meetings. He is cooperating with probation. He has an appointment scheduled with PATS this Friday for an assessment. But Your Honor, we don't disagree with the probation department that perhaps more oversight would be helpful. The sober link suggestion and such seems appropriate. Mr. Lane takes his sobriety and being sober seriously, wants all the help he can get. Offers that as an explanation to the court.
Okay, looks like I sentenced him back on May 30th. And so all of June and all of July, your tests have been positive for alcohol with pretty high ATG, if I should say so myself, 25,000 nanograms per milliliter. And I'm pretty sure you're testing in the morning, correct?
Yesterday morning.
Okay, so that's a lot of drinking. And so what have you been doing at least since when's the last time you tested?
Yesterday morning.
Yesterday morning? Was that gonna come back positive for alcohol? Okay. Well, that's positive. Looks like we're heading in a better direction. And so you've been getting some counseling and addressing the alcohol in a different way since these series of violations, sir?
Yes, sir.
Okay. I think the recommendation is appropriate at this time. I'm not gonna extend your probation just yet. I need to see what's going on and see if we have sufficient time to address it. I am gonna add an intensive outpatient services as directed by probation. I'm gonna require you to submit a 12-step meeting, which I thought was under the original order anyways. But maybe it was not. If not, it'll be added to the probation requirements. I am going to order that you get a scram tether. Actually, I'm gonna do SoberLink. I'm gonna add SoberLink for the next 3 months. Hopefully that'll address whatever issues is going on, and we won't have any continued violations related to your consumption of alcohol. If that doesn't address the issue, we'll have to go a different route, and that may mean you go to jail and then have to be remanded to inpatient treatment. Do you understand that?
Yes.
We'll try it on the outside, and hopefully we won't have to resort to that. It sounds like you're on track or on a better direction at this point. Hopefully you stay in that vein and you won't continue to use and abuse alcohol. Do you have any questions about the order of the court at this time?
No,
Okay, any additional matters for the record, counsel?
Nothing for the city, Your Honor.
nothing for the defense, thank you.
Thank you, you're all set. Joshua Rios here.
Your Honor, no, I haven't had any contact with Mr. Rios. I tried calling him, left messages, and I don't see him here, but I would ask, I have had contact with him previously, and he might have some mental health issues, so if a 48-hour hold on the bench warrant, maybe I get in contact with him, I'll let you know. Oh, yeah, did he not get his fingerprints on?
Yeah, we're gonna bench warrant him because on the 25th, he told me he was coming to get fingerprints the next day. Eldon Ward, present. Oh, he never came and signed his order of probation. Okay, let's see, Raymond Torres present? No? What's all the bad news about? Is this Mr. Smith, or who's here on behalf of Mr. Smith? Oh, Mr. Brunette is here on behalf of LabQ. Okay. On the record in the matter of LabQ versus Raymond Torres Jr., file number 16-02128. GC, appearance please.
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LabQ.
Today was the date that was set for a discovery matter. It was scheduled for 2 o'clock. It's 2:20, and no one's appeared on behalf of Mr. Torres. How do you want to proceed?
Thank you, Your Honor. Today's date was a control date for Mr. Torres to send us certain documents and to return a wage assignment to us. We didn't receive either of those. We'd asked that a bench warrant be issued for Mr. Torres with a cash bond. The judgment amount or the outstanding balance today is $574. I think perhaps a cash bond for that amount might actually resolve the matter.
Cash bond can issue in that amount.
Thank you, Your Honor.
Bench warrant will issue. Thank you. All set on that one. Now on the record in the matter of the people, I'm sorry. We're at LabQ again. Now on the record in the matter of LabQ versus Faye Brown. And that's Ms. Brown. Did you have an opportunity to meet with Mr. Brunette? Okay. File number 17-02186, council appearance.
Good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LabQ.
Okay, and then we have Ms. Brown present in the courtroom. She's indicated to the court that she did have an opportunity to meet with you. Were you able to resolve your matters?
I personally did not meet with Ms. Brown. The file that we have says that we haven't had contact with her since 2018. I don't know if Ms. Brown spoke with Mr. Smith recently. That's possible, but I didn't see any notes on it.
Okay, actually, had you spoken to Mr. Brunette? You have not? Okay, so we'll get you in a private meeting room so that you can conduct your debtor's exam, okay? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give will be the truth and the whole truth under penalty of perjury? Yes, sir. Thank you. We'll get you in a private meeting room so that you can answer the questions for the attorney, okay? Let's see, is Beverly and John Miller present? No. Okay, on the record in the matter of LabQ versus Beverly Miller and John Miller, file number 18-02296 GC. Appearance, please.
Yes, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith today on behalf of LabQ.
Okay, today was the date and time set for a debtor's exam. Let's see. Matter was set for 2 o'clock. I do have a proof of service. Neither Mr. or Mrs. Miller has appeared. How do you want to proceed?
Your Honor, we asked that a bench warrant be issued for the defendants today. The outstanding balance is fairly substantial. It's $20,220. We asked that a cash bond be issued as a part of the bench warrant for perhaps $2,000, if that's acceptable to the court.
Cash bond in the amount of 10% of the amount due can issue.
Thank you, Your Honor.
No problem. And then I'll get you in the meeting room with Ms. Brown. I thought I seen, did I admit the iPad? I don't see it.
I think I can join it myself here, Your Honor. I'll do that. Thank you.
Oh, you are. Thank you. Okay, that one's all squared away. What's your names? Dennis Patrick? Terry Sibley here? Okay, let's see. On the record in the matter of Grand Ledge Emergency versus Terry Sibley, file number 23-00618 GC. Council appearance.
Timothy Frost on behalf of plaintiff, Your Honor.
Okay, and today was date and time set for hearing for motion for summary disposition A plaintiff filed their motion for summary disposition. It was served here at the court July 13th. We do have proof of service, I believe, attached, indicating that a copy of this motion was served on the defendants. This matter was scheduled for hearing today at 2 o'clock. It's 2:26. No one's appeared. Judgment or summary disposition will be granted in favor of the plaintiff by default. Did you provide an order?
Your Honor, yes, Your Honor, it's attached to the last 2 pages to our motion. I always attach it as the last 2 pages so you can just tear it off and sign it.
Let's see. Order granted. I do see your order. I will sign it for today. Any additional matters for the record, counsel?
Nothing, Your Honor, except I think this is the first time I've appeared in front of you. So nice to meet your acquaintance.
Same to you.
And I thank you, Your Honor.
Thank you. Have a good one.
Thank you so much. You too. Take care.
Thank you. Let's see. That was Hodges. I don't know all these. Okay. On the record in the matter of LVNV Funding LLC versus Juan Navarro, file number is 23-01064 GC. Council appearance.
Good afternoon, Your Honor. Andrew Cates, P78292, standing in for the attorney of record and representing LVMV Funding.
Okay, Juan Navarro is present. Can you hear me, sir?
Yes.
Okay, you don't have an attorney representing you, is that correct?
No, I do not.
Okay, today was the date and the time set for a pretrial and a civil proceeding. Typically, I put the parties in a private meeting room to discuss the matter and see if they can either come to a resolution to resolve the matter, or they would have to complete a joint pretrial statement. Did you all get an opportunity to do that yet?
I did not.
Okay, so I'll put you in a private meeting room now so that you can do that. And then you can return to the courtroom before you leave, and we'll make sure we have either the final pretrial statement completed or a control date if necessary for any possible resolutions.
Okay.
I'm gonna put you in room 2. Okay, on the record in the matter of Anmark Rivershell versus Kimberly Watts, file number 23-01580. Council appearance.
Good afternoon, Your Honor. Brent Ingram on behalf of the plaintiff, P80491.
Okay, I do see
No,
Kimberly.
No, I said, no, sorry, get her. Hello?
I see Kimberly
Okay,
Watts
I'm
is
not-
present.
I'm here.
Okay, Kimberly Watts is present. Today's the date set for a hearing. Did you all meet privately to try to discuss a resolution?
I cannot hear you.
I have not spoken to the defendant, Your Honor. I'm amenable to talking to her in a breakout room if that's what she'd like to do.
Okay, I'll put you in a private meeting room. I'll add you to room 3.
Sounds good. Thank you, Your Honor.
No problem. He is here on that one, and he's here on the matter with Ebony Smith. then uh, Ms. Till is here on behalf of Meriwether, correct?
That is
Yes.
correct, Your Honor.
Thank you. And then I see Todd Bronson is here for Twin Oaks.
Correct, Your Honor. Good afternoon.
Good afternoon. Is Charles Ross present? Miles Hodges. Who's Miles Hodges?
I'm here, Your Honor.
Okay. Your name is Miles Hodges?
Yes, ma'am. Hodge.
What's
Yes,
your
ma'am.
case number?
Case number was 2301583 LTE.
Your matter was dismissed, so you're all set.
Thank you.
You're welcome. Do you know who Terry's Galaxy is? The person identified as Terry's Galaxy?
I believe that's the property manager for Twin Oaks, Your Honor.
Okay. You're the property manager, sir?
Yes.
Okay, sounds good. Okay, so we're waiting to see if Mr. Ross appears. Okay, Mr. Whitty, I thought I seen him.
He's here.
Mr. Whitty's here.
Afternoon, Your Honor.
Good afternoon. We have Dennis Patrick, present in the courtroom. Did you need us to get him on Zoom to meet with you?
We'd be happy to do that.
Okay. Do you have an electronic device with you at all, like a telephone? Okay, we'll get you in a private meeting room so you can talk to the plaintiff's attorney, okay? You're welcome. Are you with him? You're welcome, go with him. Okay, Mr. Brunette, I see you've returned and we have Ms. Brown back in the courtroom. Are
Yes,
you
Your
ready
Honor.
to proceed? Oh, are you ready to proceed on that matter?
Yes, Your Honor.
Okay, we're back on the record in the matter of Lafque versus Faye Brown. Counsel, how you want to proceed at this time?
We had a good discussion, Your Honor. At this time, we'd like to request a control date. I asked Ms. Brown to send us certain documents that were part of the subpoena, namely her last 6 months of bank statements, a copy of her vehicle registration, and then her most recent tax return. So we just asked the court for a control date, perhaps 30 days out, to give her some time to get those to us.
Okay. September 14th, 8:30. September 14th at 8:30, okay, ma'am? Okay. We'll get you a copy of that notice, so you know the date that you need to have provided that information before, okay?
All right, so will I get it in the mail or should I?
No, you can sit right there. We're gonna give it to you right in just a moment, okay? Do you have any questions? Okay, any additional matters for the record on this file, sir?
That is all from us, Your Honor.
Okay, thank you.
Thank you.
No problem.
Yeah, it's not letting me leave either. I don't know.
Oh, I just seen the courtroom.
Where are you
Oh,
trying to leave to?
Oh, never mind. We're there. I thought I was still in the breakout room.
Nope, you all were here.
Okay, good deal.
Let's see. Okay, let me find the file again.
Not
That's
used to
Ms.
doing this on
Watts,
my
correct?
phone. Correct,
Yes.
Your Honor.
Okay, back on the record in the matter of Ann Mark Rivershaw versus Kimberly Watts. Counsel, how do you want to proceed? Are we having a hearing on this?
Your Honor, I had a chance to speak to Ms. Watts. I think we're going to be doing a consent judgment. The amount in controversy is not being contested. However, I am going to give her until the end of the month on the writ, until the 31st.
Well, you need to put the full terms on the record because I don't have the paperwork to read it.
Understood. The rent to retain is 45,1274. Court cost is 167.50. The total redemptive amount is 46,8024. And as stated previously, the writ would be 8/31/2023.
Okay, Ms. Watts, can you hear clearly?
Yeah.
Okay, so you are looking to enter into a judgment by consent in this matter?
Yes.
Okay, so you understand that the rent to retain is the amount of $4,512.74 plus court costs of $167.50 for a total redemptive amount of $4,680.24, and that you would need to pay that or vacate by August 31st. You understand that?
Yes.
Okay, in order for you to accept or enter into a consent judgment, you would need to first waive some of your rights. And one of those rights is the right to be represented by counsel. So you have the right to have an attorney represent you during this process. And you were advised of that right back at your pre-trial, but you appeared today without an attorney. So are you waiving your right to be represented by counsel?
I guess I can
I'm
get a
sorry?
counsel.
You would have to, are you gonna hire an attorney?
Well, I don't think so.
Okay, so if you're looking to enter into consent judgment, you have to waive your right to be represented by an attorney, so it's up to you.
Okay. Yeah, I guess I'll waive it. I don't know.
Okay, well, I just need a yes or no. You have to know that you're gonna waive it. If you're not sure, we'll have a hearing today.
Yeah, I'll waive it.
Okay, and then the other waiver that I would need for you is that you understand that you have the right to have a trial in this matter, or you have the right to have a hearing. Did you want to waive your right to trial in this matter to enter into judgment by consent?
What does that mean exactly?
What does a trial mean? What are you asking?
No, you said waive judgment by consent. What do you mean?
I said you're requesting at this time to enter a consent judgment. That means judgment will enter against you for the amount of $4,680.24, and that you're consenting to that judgment. You're not requiring the plaintiff to prove that you owe that judgment. You are agreeing to it. That's what that means.
Oh, okay. Yeah.
Okay, and in order for you to do that, you have to first identify to the court that you understood your rights and that you are willingly waiving them. And so I already asked you about whether or not you were waiving your right to be represented by an attorney. Now I'm asking you, are you waiving your right to have a hearing in this matter or a trial?
Yeah.
Are you sure?
I guess so, yeah.
It doesn't sound like you're sure.
I agree on what me and him just talked about.
Okay, what did you and him talk about that you agree on? Because I need to make sure you understand that you have to waive rights in order to enter the consent judgment. And you have two rights that you gotta waive. One is the right to be represented by an attorney so you can represent yourself today. The other one is that you have a right to have a trial. And if you don't want to have a trial, then you have to waive it. And you have to tell me yes or no, not I guess so.
Oh yeah, I want to agree to by the end of the month.
Did you hear what my question was, though?
Yeah, I'm just not understanding, honestly.
I recognize that. In order for you to agree to pay or leave by the end of the month, you have to give up or waive your right to have a trial in this matter. Do you want to give that up?
Yes.
Okay, thank you. You have 3 business days from today's date. If once you leave here, you realize that you still misunderstood the rights that you just said you understood to waive, and then you can request to have this consent judgment set aside, and we can set it for a hearing at that time, okay?
Okay.
But it has to be within 3 business days. Lastly, are you giving the plaintiff's attorney permission to sign the consent judgment on your behalf?
Yes.
Okay, do you have any questions for the court?
No.
Okay, any additional matters for the record, counsel?
I don't believe so, Your Honor. I think you covered it. Thank you.
Thank you. You're all set, ma'am.
Thank you.
You're welcome.
Your Honor, at this point, would it be possible to speak to Mr. Ingram in a breakout room?
That is too funny. Okay, actually, let's see, can we put Miss Till in the room with Mr. Ingram?
Sounds good.
Mr. Properties is here. Okay, Mr. Cates is back. Do we have Mr. Navarro present too? Or is he still in
Yeah.
the breakout room?
I'm still here. I'm here.
Oh, very good. Back on the record, in the matter of LVNV funding versus Juan Navarro, counsel, did you all come to a resolution, or did you complete the joint pretrial statement?
We've actually reached a resolution in the case, Your Honor. There was just one other question I have to ask, or 2 other questions I have to ask Mr. Navarro to complete the terms. Mr. Navarro, when would you like the due date to be on the payments?
1 second, please.
Like middle of the month, end of the month, beginning of the month, you know?
The middle.
Okay, we can do that. So, Your Honor, we came to a resolution. Mr. Navarro agrees to pay the amount of $110.42 every month on the 15th of the month, beginning September 15th of 2023. He'll pay this until the full amount of the amount prayed for is paid.
Okay, Mr. Navarro, is that accurate?
Yes, Your Honor.
Okay, and then, Mr. Cates, you're gonna get that in writing and over to the court to be filed?
Yes, and the other question I'd like to ask Mr. Navarro, would he give permission for our firm to sign for him on the consent judgment, or does he want us to send it to him first?
I'm not sure what that is.
So what he's saying is that there's gonna be an agreement that you owe the amount that's due, and that you're gonna make those payments in the amount of 110 monthly. Okay, what is the total amount due, Mr. Cates?
Total amount due and owing is, hold on, $8,137.76.
Okay, and so that's the amount you're agreeing to pay in full, Mr. Navarro?
Yes.
Okay, and so he wants to reduce this agreement to a writing and have your signature attached stating that you agreed for this payment arrangement for that amount total. Is that what you want to do, sir?
Yes.
Okay, so you're gonna give him permission to sign your name to the agreement with the terms that he just stated on the record, correct?
Yes.
Do you have any questions?
No, Your Honor.
Okay, well, then you would be all set for today, and then we will get a copy of that a signed document from the attorney, and he'll send you a copy as well, okay?
Okay, thank you.
No problem.
Thank you,
Any
Your
additional
Honor.
matters? Thank you. You're all set, Mr. Navarro. Spencer, will you back? No. Still there? Okay, are you ready to proceed, Ms. Till and Mr. Ingram?
Yes, Your Honor, I believe so.
That is correct, Your Honor.
On the record, in the matter of Anmark Rivershell versus Demika Merriweather, file number 23-01582. Appearance, please.
For the record, Brent Ingram on behalf of the plaintiff.
Felicity Till on behalf of defendant.
Today's the date and the time that was set for hearing. How do we want to proceed, counsel?
I believe we would just like a brief adjournment, Your Honor. 2 weeks would be fine. I'm not sure if the 22nd works for your docket, but sounds like defendant's working with HERA and they have some questions on our end, whether or not we participate. So we're going to dig into that a little bit and hopefully get some tracks. But in the meantime, I think just putting it over is probably the best thing to do for now.
August 22nd at 2. August 22nd at 2 p.m.
Very good. Thank you, Your Honor.
No problem. Any additional matters for today, counsel?
No, Your Honor, that should do it.
Any other matters, Ms. Till?
Nothing for defendant, Your Honor. Thank you.
Okay, perfect. I will place Ms. Smith in the room with you, Mr. Ingram. Ms. Smith, do you have an attorney?
Sounds good, Your Honor.
You're muted. You're muted, Ms. Smith.
Can you hear me now?
I can hear you now. Do you have an
Okay.
attorney? Do you have an attorney, ma'am? Okay, looks like her connection is off. Not sure what's
Hello,
going on there.
can you hear me?
Oh, I can hear you now. I didn't hear your response as to whether or not you were represented by an attorney.
No, ma'am, I do not have an attorney.
Okay, I'm gonna put you in the room with the plaintiff's attorney, okay?
Yes, ma'am.
Who's on Aaron's iPhone?
Blankenberg. Can you hear me?
I can hear you, sir.
Okay.
Thank you. Mr. Ingram, I put Ms. Smith in your room.
Understood.
Okay, that's Dennis and Jessica. You're right there. Okay, what happened to Mr. Whitney? Is he still in there? Oh, he's still talking, okay. Gotcha. Mr. Woody might be back. I don't see him though. Oh, yes, I do. Mr. Woody, are you there?
I am, Your Honor.
Okay, I'm not sure where your wife is. We need to go, I guess, bring her back into the courtroom. Is Charles Ross present? See if Charles Ross. Anybody present on behalf of Charles Ross? Okay, on the record in the matter of Twin Oaks Metals versus Charles Ross, file number 23-01579, council appearance.
Todd Bronson on behalf of Twin Oaks, Your Honor.
Okay, thank you. Today was the date and the time that was set for hearing. A matter was scheduled for 2 o'clock. It's currently it's scheduled for 2:30. It's currently 2:52. No one's appeared on behalf of Mr. Ross. How do you want to proceed, counsel?
We would request from the court, Your Honor, possession judgment.
Okay, default will enter for possession only. You can submit that to Judge Simmons courtroom at lansingmi.gov, okay?
And as your writ date, the 18th, Your Honor.
Today's the 8th.
10 days would be the 18th.
Correct. That's the right date.
Thank you, Your Honor.
Thank you. Gotcha. We'll adjust it if we need to. Okay, on the record in the matter of Joe Sherrick versus Jessica Lynn Ware and Dennis Patrick, file number 23-01586, council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of Joe Sherrick, who's also present here in my office.
You and the parties are present here in the courtroom. Please state your name for the record. Jessica Patrick. And your name?
Dennis Patrick.
Okay, and today was the date and the time set for hearing. You've met privately with the attorney that's present on behalf of the plaintiff. Mr. Woody, how are we proceeding?
Your Honor, unfortunately, we weren't able to reach a resolution. I believe this is a very simple case. This is just a termination after expiration of the lease term. A copy of the lease is in the file, along with the notice of termination that was served April 17th with a termination of date of May 17th. And the lease expired on January 1st, 2023. So it's just a simple termination.
Okay, and so you all want to move forward with the hearing?
Sure.
Okay, so you believe you have a lawful reason whereby you should hold over the property?
I haven't been in court, Your Honor, for situations like this, so please forgive me. We want to move. We're willing to give up the house, but what I'm asking is for at least 60 days. She got 14 years worth of stuff in that house. We can't, me and her, we work at Ryder. I pastor a church. I'm constantly going out of town preaching. We can move, but we gotta fit it into everything that's around. Because if we don't go to work, move, we'll lose our jobs. So we're just asking for it. At least we in the process of getting a house now. We was in the process, but we got denied at the end of the process. They told us we denied. So now we had to go back to square one. So we're willing to move now with no problem. We're willing to clean up. get everything back to the way it was. We want to leave in the right manner. We just need the time.
I recognize what you're asking is for time. That doesn't give me a lawful right to give you 60 days in someone else's property if they're not willing to give it to you. The law gives me a statutory time frame that I can give you unless you provide me with some other lawful reason why you need to hold it over. And so what you're telling me, although is reasonable, it's just not lawful. I'm sorry, who's this behind you?
This is her.
Hi, I'm Sam Pearl. I submitted last week a letter regarding the defendants, just a letter of support. I'm not an attorney, but I am the housing specialist with the Site Community Action.
You submitted a letter to whom?
The court with the email on file in the instruction packet they received.
It might be at the clerk's office. It's not in the file though, I don't believe.
Oh,
okay, and what was the letter about?
Just sort of a longer term picture of what has led up to now, and also just statements of character. They are like in the Site Community Action Center's Housing Opportunity Program. I think they're very home buyer ready. They'll be prepared in 12 to 18 months to purchase a home. I have seen documentation of correspondence between the defendant and plaintiff. He has, up until as recently as last week, continued to go back and forth and say, we can work something out or we can't. I would say bad communicator at best, outright negligent and retaliatory at worst. He continues to send mixed messages. He also, without a lease, raised the rent.
Your Honor, I hate to interrupt, but this person sounds like they're making legal arguments and they're not an attorney and they're not a witness.
I'm not.
Well,
I'm just trying to content of the letter.
They've stated first on the record that they were not giving legal advice, but just trying to provide some insight as to the assistance that they've been providing the parties to try to get them, I guess, home buyer ready. Is that what's happening?
Yes.
Okay. Okay. It looks like we do have a letter here. Sam Pearl. Okay, we did. It was in the email from Eastside Community Action. I just received this and not had an opportunity to review this. Is your client here, Mr. Whitty?
Yes.
Okay. So, okay. I'm looking for your client.
If I may, Your Honor, what I was recommending they really need to say is that they do have, I don't know if it's formal escrow paperwork, that's outside my speculation. They do have in a bank account the withheld 3 months of rent. They have an ongoing maintenance request that has not been met, and they also.
You have an escrow already?
I have it, the monthly payments in my savings account.
Okay, so you have not paid rent in the last 3 months? Well, because you've been escrowing it? Why, what was the issue?
Because we need it for movement, we're getting evicted, we need the money.
Was there a pending maintenance issue that wasn't addressed?
I have asked him to come in. And
well, just tell me yes or no. I don't want to get into detail. There's a pending maintenance, and so because of that maintenance issue, you decided to escrow your rent, correct?
Yes.
All right. I'm resetting this for an in-person hearing. You need to bring evidence of the issues that you're alleging was not addressed, okay? To August 23rd at 9:30. Okay, August 23rd at 9:30. So what's that? 9:30. At 9:30. We doing hearings in the morning? This is civil docket. Oh, okay. August 23rd at 9:30 work for you, Mr. Whitty?
That does not. I've got a hearing in circuit court at 10.
Yeah, I know we don't typically do hearings in the morning anyways, but let me see here.
That.
Oh, September 6th work for you at 2:30?
I've got some other in-persons, but they're all in 54A, so I can make that work.
Okay, we'll do September 6th at 2:30, and then everyone will appear in person, and then you all can bring the evidence that you have to support the issues of the outstanding maintenance that's not been addressed. Do you have any questions at this time?
No, Your Honor.
Okay, we're gonna get you a copy of your notice to appear for that date, and then you'll be all set for today. Any additional matters for the record today, Mr. Whitty?
None, Your Honor. Thank you.
Okay, you're all set. You can have a seat.
Thank you, Your Honor.
You're welcome. Okay, let's see. Is Mr. Dewar here?
Your Honor, Ronald Bach, I'm appearing for Mr. Dewar today.
Oh, wonderful. Okay. Mr. Blackenberg is present. I know I saw him. Mr. Blackenberg, you do not have an attorney, correct?
No, I don't.
Okay, I'm going to put you and Mr. Bach in a private meeting room to discuss this matter.
All right.
Thank you, Judge.
No problem. Room 1. Blackenberg, room 1. Who's here for Mr. Wasbury? Oh, Miss Snyder. Okay. Miss Snyder, can you hear me?
Yes, I can, Your Honor. Good afternoon.
Is Patrick? Good afternoon. Is Patrick Lowry present?
Yeah, Your Honor, we had to dismiss his case. He paid back in June, and we should have dismissed it back on at the end of June.
Did I just sign a dismissal? Oh, I actually just signed the dismissal.
I just sent it over, so I appreciate that, Your Honor.
Okay, no problem. And then you have a couple at 3 o'clock. I see Miss Till is here. Miss Till, did you need to meet with her?
Yes, is Miss Soleo in the courtroom, Your Honor?
Yes, I'm sorry. Yeah, she's present.
Could I meet with her over the iPad if possible?
No problem.
Thank you.
Okay.
Your Honor, I was having some issues with the meeting room and I got booted out. I was
Okay. Mr. Ingram, do you need to go back in the room with her?
That would be agreeable. I honestly wasn't sure what was going on, so I just came back out because we just got early, but
her internet was a little low earlier, so it might have booted her.
It booted me out. So
I'll go back. I'll go back to
I'll put you back in room 4.
Thank you.
Thank you, Judge.
No problem. Let's see.
Your Honor, I have a quick question. I'm here with Ron Bach, and I wasn't put in the room on behalf of TC Cornerstone Properties.
He didn't ask me to put you in the room. I only put them in when they asked me to put you in because I don't know what the attorney wants.
Okay. Yeah, he's my attorney, so okay.
Sounds good. He may come back and ask me to add you. And at which point I'll do that.
Thank you, Your Honor.
No problem. And let's see, Bollinger is on what matter?
He's my client, Your Honor.
Okay, wonderful. Let's see. So I don't have any more tenants, I think, on here. Ryan Anderson and we have Bollinger. Okay. Mr. Bach, did you need me to put your client in the room with you?
No, Your Honor, I think we have an agreement. He said he'll be out by the weekend, so we were just going to agree to a consent judgment with the normal 10 days, but he said he's going to turn in the keys this Saturday either way. And this was only about possession. There was no money judgment requested.
Is Mr. I don't know if he's back yet. Let's see. Mr. Blackenberg? Oh, he is back. Okay, so he's going to turn in the key this weekend. So do you want me to just reset this and then you can get the key, or I don't know what you want to do today?
Well, I thought we would just do a consent judgment with the normal 10 days, but he said he'll be out before then either way.
Mr. Blackenberg, let me call the case. On the record in the matter of TC Cornerstone versus Aaron Blackenberg, file number 23-01587 LTE, council appearance.
Good afternoon, Your Honor. Ronald Bach here for plaintiff, TC Cornerstone.
Mr. Blackenberg, you need to unmute your device, please.
Hello?
Yes, and so today's the date and the time that's set for a hearing on an eviction for non-payment of rent. My understanding is that you want to enter a consent judgment. So that's, you're entering to judgment without having a hearing. Is that what you want to do?
Yeah, I don't need no hearing. I want to move anyway. Air
Okay.
conditioner don't work and it's hot. It's hot. It's hot.
Okay, but what you're entering is for judgment to enter against you, though. That's what a consent judgment is. You understand that?
What you mean by against me? Like giving up possession?
That means that a judgment will enter against you for possession of the property, and if you don't move it, they can get rid of eviction and remove you from the property. This is not a settlement, whereas there won't be a judgment against you. That's what I'm saying.
So if I say yes to this, I gotta be out within 10 days.
You have to be out within 10 days, but you have to waive certain rights in order to have this judgment enter against you.
Well, I want to give the keys up and stuff, so I guess that's what I should do. That's the judgment is saying that I want to get the keys up, right?
The judgment is saying that you are conceding to give them the keys. There's other ways that this issue can be resolved because it's for possession, I'm assuming. They could have entered a consent judgment with you, which is what they're trying to do. So judgment will enter against you by consent if that's what you want to do. They could do a conditional dismissal, meaning there won't be a judgment against you and you turning your key, or you can proceed to a hearing.
Well, what's a conditional dismissal? Give it the keys and they dismiss it?
That's correct.
That sounds a little better to me.
Well, that's what you guys doesn't sound like you guys negotiated that. Do you guys need to go back in the room?
I didn't know that was an option. Yeah, I guess not. I guess I would rather have a conditional dismissal.
Okay, you guys can go back in room 1 and talk about it. I don't know what that
So what's the
state you all talk about. With the conditional dismissal, they'll dismiss the case upon the conditions that you do whatever they need you to do, whether that be pay rent or give them your key, whatever it is that you guys agree to.
Can he hear you now, or we need to go back in the room?
Yes, I can hear you.
He can hear you. You all can just go back into room 1.
All right, let's talk real quick.
That sounds good, Judge. Could you also send our client, Mr. Elliott, Geib or Gelb?
I'll put him in room 1.
Thank you.
No problem. You're gonna have to just return to breakout room, sir. You should see it on your screen.
Okay,
Breakout
I see
room.
it. I see it.
Okay, Letizia Blaze, did I say it right? I'm not sure.
Blaze. Yeah.
Okay, Ms. Snyder. Nope, that's not Ms. Snyder. That's Mr. Bronson. Ingram. I don't, is he still here? Okay, sounds good. Did we see, what happened to Porter? We didn't see them? Wait, which one did we just?
Do I need another invite to get back to breakout room 1?
Nope, you have to just return to breakout room. You're already there.
Not there.
Uh-oh, did we? I don't see Mr. Bach. Let me move you all to room 3. Room 3. Room 3. Okay, Patrick Lowry, we didn't see him.
That was the dismissal.
Okay, that's what I thought. I still have that file. And then Porter.
Order.
Okay, sounds good.
Your Honor, could I be placed in a breakout room with Ms. Snyder?
And if we could include James Bollinger in that breakout room as well, I'd appreciate it.
Let's see. This is. Okay, Mr. Ingram, Ms. Smith, are you ready?
Yes,
Yes,
ma'am. Here.
Okay, on the record, in the matter of Ann Mark Rivershell versus Ebony Smith, parties have met. Counsel, how do you want to proceed?
I had a chance to speak to Ms. Smith, Your Honor, and it sounds as if there are some issues with her accounting in the ledger. I would like to try to sort it out with her. So at this point, I'm asking to just put this over until the 22nd. And hopefully she did provide her contact information. We can figure it out, perhaps deal with it with a conditional dismissal.
Okay. I can't hear you. You said what?
We can do the 22nd at 2:30.
This, the 22nd at 2:30.
Very good, thank you.
Okay, do you have any questions today, Ms. Smith?
That was August 22nd at 2:30, correct?
Yes, ma'am.
Am I going to receive paperwork, or am I the one that I have the, what else?
You'll get a new notice in the mail.
Okay.
Do you have any other questions?
No, ma'am.
You're all set.
Thank you.
You're welcome. Nikki or Nick, I'm not sure what's happening here.
Who's Nikki?
It says Nikki there. That's a big comma. It's a little green sticky for you.
You'll see anybody else in there?
Nikki.
Oh, actually, okay.
Can I be placed back in the breakout room with Miss Alea on the courtroom iPad?
You're already in room 2.
Okay, perfect. Thank you.
No problem.
She was just meeting with.
Ms. Snyder, who were you just meeting with?
I was just meeting with Miss Till about Soleo.
Oh, okay, sounds good. And then Jonathan Porter, I don't think the Porter appeared.
Okay.
You can submit default.
Okay, I will submit a default. Thank you, Your Honor.
No problem. Still on that one, and then Mr. Ingram. Can I put Ms. Blaze in the room with you?
Of course, Your Honor.
Okay. Let's see, Blaze and room 4. Okay, Ms. Till.
Yes, Your Honor.
Okay, were you ready? Your client is back. You can come up to the table right here, ma'am.
Yes, ma'am.
Let's
Yes,
see.
Stand up, down.
You can have a seat. On the record in the matter of VTP Capital Village versus Ursuline Celio. Celio, thank you. File number 23-01604 LT, council appearance.
Thank you, Your Honor. Jackie Peter on behalf of Mark Wadsbury, 82554 is my fee number. We represent Capital Village Apartments in this matter.
Good afternoon, Your Honor. Felicity Till, P83961 of Legal Services of South Central Michigan, appearing via Zoom for the defendant, Ms. Cilio, who is present live in the courtroom.
Thank you. Today was the date set for a hearing on an eviction for non-payment of rent. How do you want to proceed on this at this time, counsel?
Your Honor, we are requesting a 1-week adjournment. We are waiting to hear back from the assistance programs, and we are hoping to hear back from them by this Friday. So if we could have a slot on the August 16th date, I would appreciate it.
It's later than that, correct? Yeah, full. We're all full. Let's see.
Do you have anything on the 15th?
No, we're doing an exam that day.
Would there be,
Does the 17th work for you?
I can do the 17th.
What time, Your Honor?
9 a.m.
I can do that.
I can see if Mark can do it. It looks like I am in Detroit in person, so, but he should be fine to do it.
Okay, we'll reset it to August 17th at 9 a.m.
Thank you, Your Honor.
Thank you, Your
No
Honor.
problem. No problem. Any questions for the court today, ma'am? Okay, any additional matters for the record, counsel?
No, Your Honor.
Nothing for defendant, Your Honor. Thank you.
Okay, thank you. We'll get you, Mr. Leo, we're gonna get you a copy of your notice to appear, okay? Thank you.
Thank you, Your Honor.
And you and your staff have a wonderful day, Your Honor.
Same to you. Mr. Bob, are you ready with Mr. Blackenberg?
Yes, Your Honor. We've decided to do the conditional dismissal, but it will be the same terms. I'm actually typing it right now, and I can have it to your office in the very near future. Being that this is only about possession, he's planning to move out this weekend. We've agreed that if he's not out by the 18th, then on the Monday after that, which is the 21st, then we could file the judgment and order of eviction then. Sounds like that's not going to be an issue because he'll be out. But either way, this case will be conditionally dismissed on those terms.
Sounds good. Mr. Blackenberg, can you hear me?
Yes, I can.
Okay, so you want to enter in a conditional dismissal whereby you would vacate the property no later than August 18th, leaving the property in broom swept condition and turning over the key to the landlord. And in exchange, they're going to dismiss the case. Is that correct?
Yes.
Okay, and so you want to give up your right to be represented by counsel in order to enter into conditional dismissal?
Yes.
And you also want to waive your right to have a trial in this in order to enter conditional dismissal?
Yes.
Anybody threatening you or making any promises to you to get you to waive those rights?
No, not at all.
Okay, very good. You have 3 business days from today. If you leave here and you realize you misunderstood the rights you're waiving, you can request to have this matter set for a hearing, okay?
Okay.
You should understand that partial performance will not satisfy the conditional dismissal. So you need to move before the 18th. You need to remove all of your things. You should probably schedule a walkthrough and turn in your key so that you don't have any issues. Otherwise, they can request a written judgment against you after the 18th, okay?
Okay.
Do you have any questions for the court?
No.
Are you giving Mr. Bach permission to sign the conditional dismissal on your behalf?
Yes.
Okay, any additional matters for the record, counsel?
No, Your Honor. I will have that conditional dismissal emailed to your office in the very near future.
Wonderful. Okay, you're all set for today, Mr. Blackenberg.
Appreciate you.
Thank you, Judge.
Have a good one. Thank you. Let's see. Ms. Blaze, okay. Are we ready on the matter with Ms. Blaze?
We are, Your Honor.
On the record in the matter, 100 Townhomes Properties versus Letizia Blaze, file number 23-01615 LT, appearance for the record.
For the record, Brent Ingram on behalf of the plaintiff.
Okay, and then Ms. Blaze is present via Zoom without counsel today with the date set for hearing for non-payment of rent. Did the parties enter an agreement at all?
We did, Your Honor. We're going to be doing a consent judgment for the rent to retain of $41.66, court costs of $167.50, total amount owing $4,333.50. I have agreed to put the writ out to 8/31/2023, Your Honor.
Okay, Ms. Blaze, is that how you want to resolve this with a consent judgment?
Yes, ma'am, it is.
Okay, so you understand that in order for you to enter consent judgment, you have to give up a few rights?
Yes, I do.
Okay, so you want to enter into judgment by consent for the amount to retain of $4,166 plus court costs in the amount of $167.50 for a total rent to retain retention amount $4,333.50, and that you will pay that or vacate the property no later than August 31st. You understand that?
Yes.
Okay.
Yes,
And
Your Honor.
anybody, okay, you understand that you have the right to have an attorney represent you at this hearing?
What was that?
You understand that you have the right to have an attorney represent you during the eviction process?
Yes, I do.
Okay, you also have the right to have a trial in this matter or a hearing. You want to waive your right to trial in this matter?
Yes, Your Honor.
You want to waive your right to be represented by an attorney in this matter?
Yes.
Anybody threatening you to waive those rights?
No, Your Honor.
Okay. You have 3 business days from today. If once you leave here, you realize you misunderstood the rights that you just waived, you can request to have judgment set aside, and then we'll set this for a hearing date. Lastly, are you going to give Mr. Ingram permission to sign the consent judgment on your behalf?
Yes, Your Honor.
Do you have any questions today?
No, he answered most of my questions.
Very good. Any additional matters for the record, counsel?
Not at this time, Judge. Thank you.
Okay, you're all set, ma'am. Thank you.
Thank you.
You're welcome.
That should be it for me, Your Honor. You have a good afternoon.
Same to you. Oh, Ryan Anderson?
Yes, it's me. Yes, Your Honor. I am the property manager of River Shell Apartments. Swiss Stack Levine is the counsel that represents my management company.
Okay, we resolved the remaining of your matters.
Have a good